Hello and welcome. My name is Graves Theus. I'm an attorney in Alexandria, Louisiana. I'm licensed to practice in 3 states, Louisiana, Washington, and Alaska. I'm an estate planning specialist, certified by the Louisiana State Board of Legal Specialization. I'm also a tax law specialist. I've been practicing for over 20 years. So welcome to Theus Law Offices. I'd like to talk to you a little bit today about the nuts and bolts of estate planning. One of our biggest missions and challenges as a law firm is to dispel much of the misinformation that is circulating out there about this topic of estate planning, so that you can be more informed and make better choices. At the end of the day, that's what this is about. This is a much more abbreviated version of what we would normally do in a live presentation, where we can take questions on the spot and get those questions answered. We can't do that in this format. So we're going to make a special offer to you at the end of the presentation for a free consultation if that's something you want. Likely this presentation will raise some questions for you, and that's really my job, is to get you thinking about your assets, your decisions, and your estate plan, to make sure that you take whatever action you need to take, if any. So that said, let's got a lot of ground to cover. Let's jump right in. Hello and welcome to my office, which is where I personally meet with clients on a daily basis. Our office is located in Alexandria, Louisiana, in an old historic building. It's about 100 years old. We've completely refurbished it and preserved the beauty and the architecture, but we've also equipped it with state-of-the-art technology, such as fiber optic cable, large screen monitors, and a tremendous network that allows us to meet with clients all over the world. And we do, and we could work with you too in the comfort of your own home. So let's do this now. I'm going to share my screen with you, and we'll walk through a few presentation slides that cover just some of the fundamentals of estate planning. So let me jump in and start the show. So the title to this presentation is, do you need a will, a trust, or neither? Which is a pretty basic question for most of us, especially in these uncertain times. So if you take one thing from this presentation, it's that knowing isn't enough. You have to act. If a dentist tells you that you have a cavity, you need to do something about it. It's great information, but unless you do something about it, it's only going to get worse. Problems don't just go away, so you need to act. That's the takeaway. Your goals for this workshop should be to understand as best you can what it takes to properly plan and protect your estate, and to identify if your current plan, if you have one, meets your goals, whether you're all set. How do you know if you're all set? Well, if you hear something and you like it and you have it, maybe you're all set. If you hear something and you like it and you don't have it, maybe you're not. And then lastly, know how to get what's missing. And so we'll cover that in the last part of the presentation. So here are some common questions that we address normally in a live presentation. We'll try to cover these as best we can in this format. Do I need a will, a trust, or neither? What's a trust? What's the difference between a revocable and an irrevocable trust? Do I really need to avoid probate? If so, how do I do it? What's a power of attorney? What's a living will? And why are they important? Can I protect my assets from unforeseeable claims, creditors, my own family? How? Do I need to? Do I need to worry about long-term care costs? Should I give my assets away to the kids to avoid long-term care costs? The answer to that is no, and I'll tell you why. Do I need a trust? Not necessarily. Does it take 5 years? Not necessarily. When and how do I plan for irresponsible, minor, or disabled beneficiaries? Do I need any special planning for my IRA, life insurance, retirement plans, anything that's governed by beneficiary designation? And how do I avoid estate taxes? Or do I even need to? Probably not, unless your estate is worth more than $11.5 million if you're single, or $23 million approximately if you're married. But we'll cover that later. Now, before we get started, let me tell you a little story about a lawyer. And his dad was a lawyer, and his dad was a lawyer, and he lived in a house in Monroe, Louisiana on the bayou. And he had a wife and he had 2 kids and he had a pontoon boat. He liked to fish and he liked to take slow rides up the bayou with his wife after work to enjoy the sunset. And one day he's enjoying the sunset, and the next day he's charging the boat battery, standing in the water, and the cable falls out, and it's lights out. Now, imagine an 8-year-old kid who walks in on his parents to find them just beside themselves at the shock and awe of this unfortunate accident. And it's an eye-opener. Life is fragile. So you need to be prepared 3 ways: legally, financially, and emotionally. It's hard to prepare emotionally even if you see it coming. But if you're not prepared legally and financially, it makes the emotional stuff 10,000 times worse. So that kid grows up to become a lawyer, and that's what we do, is help people prepare legally and financially for what's next. But remember, estate planning isn't just about what happens at death. It's also about what happens during life, while we're alive, staying in control, making sure we don't become a burden on anyone, making sure we don't outlive our money. These are important things. And that's what this is about, really, is, how to properly plan and protect our estate while we're here and now, and also to protect our legacy for what's next. And how do we do that? Well, we can accomplish that really in 3 simple steps. 1, you got to know the rules. Once you know the rules, you can start making the rules work to your advantage. Everyone does it. 2, know your threats. These are things that threaten your financial position, things you need to be aware of. And 3, know your options. That's the brass tack stuff. How do we do it? And so we'll cover these 3 things in the balance of this abbreviated presentation. So let's start with the rules. First, the state of Louisiana has rules for you while you are alive and after we're gone. And these rules relate to who has the authority. It's always about who has the authority. Who's in control, who gets to benefit, and when. Remember those 3 questions. Who's in control, who gets to benefit, and when. Why? Because this is estate planning. Making decisions now while you can, before you can't. And there are 2 sides to the estate planning coin. 1, death planning. Making decisions for the certainty that none of us are going to make it out of here alive. 2, lifetime planning. Making decisions for the real possibility of our incapacity, or simply protecting our assets even though we do have capacity. So, do you have an estate plan? Yes, you do. You either have the one that you make while you can, or you have the one that the government has for you if you don't. So you have 2 choices. Do nothing and opt into the government's estate plan, or you do something, which just means a last will and testament or a living trust. So what if you do nothing? You're on the government's estate plan, which decides who's in control, who gets to benefit, and when. And the people within this pool generally are your spouse, descendants, other relatives, and what we call laughing heirs. Who are these people? Laughing heirs are related to you proximately, and because of their proximate relation to you, may end up with a windfall, in which case they're laughing all the way to the bank, and that's why we call them laughing heirs. And intestate succession, that's what happens when you die without a will, is ripe for dispute. Why? Because a probate is a lot like a divorce. We live in a community property state, and so whenever the community terminates, whether it's at death or at divorce, there's a settling up, and everything gets laid out on the table. So we're fighting about whether the characterization of property, whether separate property or community property, that makes a big difference in where it goes. Spousal reimbursements. If one spouse, improved property of the other, then they get paid back at some point. So we fight about that. Control is a big strategy play, a race to the courthouse, because the first one to get there controls the funds of the succession and can arm themselves. Forced heirships, strained relationships, unintended consequences. It's not where you want to be. There's no reason you need to do that. So who in the world would die without a will? Well, James Dean, Prince, Abraham Lincoln. And they're probably still fighting over Abraham Lincoln's estate to this day. So you should do something. What does that mean? Simply do a last will and testament or a living trust. So what's a will? This is the legal definition of a will. It's a lot of, kind of lawyer words, but really it's just a gift that takes effect at death. And for that reason, you can change it any time before you die. There are two kinds of wills in the state of Louisiana. There's an holographic will, which is, another word for a handwritten will. It has to be entirely in your handwriting, dated and signed at the end. Dated anywhere in the body of it, but signed at the end. Don't use a kind of a partially pre-filled form that says, I leave all my stuff to printed, and type pre-typed. I leave all my stuff to blank, and then you fill in the blank. That's not a valid will because it's not entirely in your handwriting. Some people get these things notarized and witnessed. They don't have to be witnessed or notarized. It just has to be entirely in your handwriting, dated and signed at the end. It's a valid will. The other kind is a notarial will. A notarial will is usually prepared by an attorney. It's more comprehensive. It has to be in a certain form. If it's not in the right form, then it's not a valid will. It also has to be executed in a certain way. There's a certain formality, the execution, a ceremony that you have to go through when you execute a notarial will. If you don't follow that, the will is valid, even if it's in the right form. So, these are better, but you just need to be careful about how they're executed. Wills, any will, whether it's holographic or notarial, is, lots of disputes happen in will contests. So a word on holographic wills. Here's an example of one for you. Aretha Franklin is obviously a famous person. She died recently. And she had 3 holographic wills that have been discovered, at least to date. 2 were discovered in a locked cabinet. Another one was discovered in a couch cushion. So, which one of those is valid remains to be seen. That estate is going to be litigated for many years to come. But, the problem with holographic wills is just trying to figure out what the person intended when they wrote it, because lay people, most people don't write like lawyers. Lawyers write in a certain language we call legalese, and it's very, very precise. And most people don't talk that way or write that way. And so often it's difficult to figure out what somebody really meant. And an holographic will is kind of a dangerous thing because, you can write it out on a napkin, on the back of an envelope, and, there's often disputes as to whether this was even supposed to be a will. So, it maybe is a good thing in an emergency, but if you've got time to do something else, it would be much safer to go the other direction or option in Louisiana and use a notarial will. So what does a will cover? It covers probate assets. Probate assets are things that you touch, like a house, a vehicle, an investment account. These things are governed by your will. The will does not govern certain things, which we call non-probate assets. These are, things like life insurance, use of property, retirement benefits, property that's already in a trust, and pay on death accounts. Those are governed by beneficiary designation. So you want to be careful about making sure that if you've got a will-centered plan, that your non-probate assets dovetail or integrate with your probate assets. because it's not uncommon to see, someone who says in their will, I want so-and-so to get my life insurance and I want so-and-so to get my annuity. And guess what? It's the beneficiary in the annuity and the life insurance that's going to get that stuff, or there's going to be a dispute about that. So, and you want to make sure that's the same person at least. If it isn't, we got a problem. So a will is a gift, but when someone passes away, that doesn't magically make the gift complete. To make it complete, you have to go through the probate process, which is really just an awkward act of conveyance, getting the assets of someone who passed away to the people who are supposed to get them. And so it requires that it's a judicial process, like a lawsuit, where you file pleadings and you file the will and you get somebody appointed to be in charge of your estate, pay or provide for debts, prepare an inventory of all your assets with fair market value, and a few other pleadings, and ultimately a judge will be presented with what we call a judgment of possession, which will say, this person gets this person gets that, and the other gets the other thing. And the judge's signature has the force and effect of law, and so that's what makes the probate complete. That's what puts people in possession of assets, his juridical act. So you just have to recognize that a will necessitates the probate process. Now, is that a bad thing? Not necessarily. It depends. But some considerations are, again, probate is a lot like a divorce in that all your personal business is laid out to the public. And anyone can access your court files, read the will, details about your family. So if that's an issue, then you may want to go a different direction. It could invite claims. People do monitor the court records as they're filed in real time. The cost of a probate is a consideration. Court costs, start at about $500. If you need to do anything, administer anything, it's going to go up from there. The attorney's fees are supposed to be reasonable in the state of Louisiana. Some people charge a fixed fee. Some people charge a percentage-based fee. Some people charge a flat fee. Maybe lowball kind of average rate would be in the $5,000 range, although some attorneys do overcharge, and it can be quite expensive. If there are any issues, litigation generally, whether it's a state litigation or any other matter, you measure that typically in $10,000 increments. Executor fees are also an issue. The state of Louisiana, by statute, the executor is entitled to 2.5% of the total value of the estate as a fee. Often that gets waived, not always. It just depends on who's on the other end of that. And of course, you have the cost of the will itself. And there's a bit of a delay, probably 6, 9, 12 months is about par for the courts if there are no issues with the succession. If there are issues, then it takes a lot longer. I've got one under administration right now that's been under administration for going on 10 years. So that's not a good thing. So who in the world would really go through the courthouse files? Well, here's a real example of something I received recently from the Department of Health and Hospitals related to the succession of a client who was a Medicaid recipient. And, as soon as we file the pleadings to open the succession, that gets published in a legal recorder, and a lot of people pay attention to that legal recorder. So they are on standby and monitor the legal recorder. And so this is basically a bill or notice that of estate recovery in the amount of $247,000, which is how, the bill basically that this person ran up as a Medicaid recipient. And so that's part of the Medicaid comeback is estate recovery. They're by law entitled to, required to recover or attempt to recover from an estate of a decedent any amount in excess of $10,000 that was, in expenses that was incurred on behalf of that Medicaid recipient. So credit card companies do it as well, and lots of other people kind of monitor the probate records because they're all digital now. So is there a way to avoid this altogether? Yes, there is. It's called a living trust. And so this is designed specifically to avoid the probate process. It's private, and it's a different way to get to the same place. They were actually invented in California some time ago, and the reason they were invented, little trivia here, is that attorneys were paid by on a percentage basis in California for a probate. And so if you live in California and you have a house, just a house, you're a millionaire. And so, if an attorney gets paid a percentage basis, a percentage fee to probate a house that's worth over $1 million, that's a pretty darn good fee for just probating a house. And so that's, the cost benefit doesn't measure out. And so some smart guy figured out, well, let's just set up a trust and we'll transfer the assets to the trust before somebody passes away. And then the trust will have instructions to distribute the assets to whoever is supposed to get them. And we don't need to go through the probate process. But I'll tell you how that works later. So let's talk about lifetime planning. What if you don't die? Who has the authority is, again, the issue. And the person who has authority in the event of your incapacity is determined by your power of attorney. And then there's your healthcare directive as well. And a healthcare directive, I'll explain in a minute, doesn't grant authority to anyone. It just simply expresses your wishes as to the extent you want life-sustaining procedures to be employed if you can't express those wishes yourself. So what might cause incapacity? Accidents, injuries from activity, medical conditions. What's circulating right now is a very good example of what can, quickly result in incapacity or worse. Degenerative diseases, Alzheimer's, anything that prevents you from acting on your own behalf. So what is a power of attorney? It's simply a legal document that appoints someone you know and you trust to make financial and healthcare decisions for you when you can't do that. So there's a financial power of attorney and a healthcare power of attorney. Sometimes they're rolled into one document. I break them up into two because someone with a good business head may not have the best bedside manner. Conversely, somebody with a good bedside manner may not have a very good business head. So you may not want the same person to do those jobs, but they're both really, really important because when you need a power of attorney, you really need it. And if it doesn't work, then you got a big problem. And same with the healthcare directive. It doesn't grant any authority. It expresses your wishes regarding the types of medical life support measures you prefer to have or to be withheld. If you're in a terminal condition and can't express those wishes. Now, if you don't have these in place, what happens? You go to court. And, if we're talking about who's going to make financial and healthcare decisions for you, then the judicial proceeding is called an interdiction proceeding. And what that is authorizing somebody to act for you. And what it requires is that you be declared incapacitated or incompetent. And if you are declared incompetent, you no longer have the right to your innate constitutional right to life, liberty, and the pursuit of happiness. You're no longer a person. So it's a really extreme remedy, and for that reason, it's a really high burden to get there. even if it's clear and convincing that the person is incapacitated because they're maybe in a coma, you still have to get a court-appointed attorney for that person. So you got 2 attorneys, 2 experts, multiple proceedings, and it gets expensive quick. Now, is there an alternative? Yeah, get a power of attorney. Just make sure it's a good one. Now, if you don't have a healthcare directive, then it's the same thing. You end up in a kind of a right to die dispute, and you don't want to go there. So get a good healthcare directive. So let's talk about our predators in the next section. So you have 3 threats to your estate plan and your assets. 1, not knowing the law. Ignorance is bliss sometimes, but it can also be catastrophic. So not knowing the law. You don't know what you don't know. Not knowing your risks. So what are the things that threaten your financial position? And 3, failing to plan when you can. And that's just another word for procrastination. So a word on generic will kits. I'll say this: it's safer to do an holographic handwritten will than it is to pull something off the internet. These things are widely available from the consumer perspective. They're super cheap and easy, but they're dangerous. You can get them at a box store, and it may say valid in all 50 states, and there may be a little asterisk that says except Louisiana, because we are we're a different place. And so we are a real law firm. We litigate estate cases frequently, and a good example of what can go wrong is in the succession of BizCamp, which is a Third Circuit case, and you can go look that up if you're bored. But the basic facts of this case were Mr. BizCamp. He was a kind of a not a very nice guy, and he drank a lot. He was cheap, and so he bought this, got this will somewhere on the internet, and he downloaded it, and he left all his stuff to someone and cut out his daughters, who hired us to knock it out. So we have a pretty good nose for what works and what doesn't. It didn't. We knocked it out. When you lose, you appeal. So it ended up in the Third Circuit. And the Third Circuit had seen enough of this and really, gave a public service announcement, is what this language sounds like. Given the reliance, these are their words from the screen, given the reliance on computer-generated testaments, we, the court, strongly feel the public would benefit from the form provided by the author. And so what happened there? They looked at the clause at issue, which was not spot on. It's not like, horseshoes and hand grenades. If it's not spot on in Louisiana, it's absolutely null. So the clause has to read a certain way. It didn't. They published the way it's supposed to look like, just to, let it be known. But nobody is going to go find this case in real terms and compare what they're looking at to what it's really supposed to look like. So you just don't know. It's dangerous. It's like a box of Cracker Jacks. You never know what you're going to get. So just be careful with online wills. They're dangerous. The other one to watch out for are using, the family lawyer. A lot of families have the family lawyer, and a lot of people dabble in this stuff. What's so hard about a will, right? Well, it ain't so easy. And so a lot of people get it wrong. And go look up Succession of Ivy. It's another Third Circuit case that we litigated. And that is a local attorney, a repeat offender who just botched the will. And unfortunately, so for the surviving spouse who, second marriage, she does not have a home because of this. So there are real consequences. Another example of using, somebody who dabbles is, an individual. I reviewed recently a trust that turned out to be my trust. And somebody simply copied it and changed the names, but they screwed up because they put, the principal beneficiary as a settlor, which is a big mistake because Medicaid was the object to kind of start the clock on that. And he screwed up. So 5 years later, fortunately, I looked at it, but person was ready to check in. and the clock had not started. So it was really a catastrophic mistake. So it's not just so easy as plugging in names. It's a super complicated area of law, and so people dabble in it, unfortunately, and they should not. So be careful. Not knowing your threats. What are your threats? The government. Of course, taxes, income taxes, federal estate taxes. I don't think most of us don't need to worry about federal estate taxes anymore, because the exemption levels are so high. $11.5 million per person, $23 million roughly for a married couple. If you've got less than that, you don't need to worry about it. Probate, we talked about. Interdiction, we've talked about. Those are, predatory. Your family, believe it or not, your spouse, whether it's divorce or maybe remarriage after you pass away, those affect your assets. Your children, future failed marriages, bankruptcies, other issues they face. These are threats to your financial position. Lawsuits, creditors, that's a big one in Louisiana. Long-term care costs are another big one in Louisiana, or anywhere really. So let's talk about lawsuits for a second against you, your spouse, your kids. Anybody you're responsible for rolls up to you. And we live in an unusual legal climate. We have, billboards all around us that are mostly attorney advertisements. We have result-oriented judges and these expanding theories of liability. There's no such thing as a sure miss in Louisiana. There's no loser pays rule in Louisiana. What does that mean? If I sue anyone, there's a nuisance value to that lawsuit, regardless of whether it's the suit has any basis or not, because it may be more expensive to go to court and just deal with it than it is to simply pay the person off to go away. And so that's what a lot of insurance companies do, is they simply say, here's some money, go away, just so we don't have to litigate. So if you file a same bogus lawsuit in Texas, there's a loser pays rule, which means that if you don't win, you're going to have to pay the attorney's fees for the other side. That doesn't exist here. So, even if you get sued in Louisiana, you already lost even if you win. Louisiana is a, quote, legal hellhole. This is a direct quote from our esteemed insurance commissioner, Jim Donnellan, from last year. Why? Because 8 out of 10 auto accidents will be litigated in Louisiana. Is that normal? No. What's the norm? Maybe 2 out of 10 or less in every other state. It's got the highest auto insurance rates in the United States. We're the most litigious state in the country, arguably. So we're highly litigious, and we're also not very protective. So highly litigious, and not a lot is safe in Louisiana. For example, these are things that are exempt from seizure and sale if you get popped with a lawsuit. $35,000 of equity in a residence. Put that in perspective. The average cost of a mobile home in Louisiana is over $73,000. So not even half a mobile home is protected in Louisiana. Remember when OJ got popped with a judgment, a civil judgment, what did he do? The first thing he did was buy a very expensive house in Florida. Why? Because your house is your castle in Florida. It can't be seized. That's not the case in Louisiana. What else is protected? Dogs, cats, household pets. They can't be taken from you. Keep in mind that a golden-haired Tibetan Mastiff puppy sold in China for $2 million recently. So if you can't pull the OJ move, consider buying a really expensive pet if you find yourself in dire circumstances. Tools of the trade, 1 utility trailer. Personal property, 1 cow for family purposes. The family cow is protected. That's about it. Retirement plans are a safe haven as long as they're not in pay status. But, this is antiquated stuff. That $35,000 figure just got bumped up from 25, so that's a new number, thank you. I think the public policy probably behind this, statutory scheme is that, there's no debtor's prison. And so we shouldn't deprive someone of absolutely everything. So what do you really need to subsist as a person? A $35,000 house, a cat, a utility trailer, and a cow, and maybe a campfire and a fiddle. And that's where we are in Louisiana. So, it should cause you to think about asset protection in this state, which is just the process of arranging your affairs in a way that mitigates the risk to which those assets would otherwise be subject. It's not hard. A lot of people do it. In any way, you don't have to transfer value. You just have to arrange your affairs in a certain way. It's just something you should think about in Louisiana. Now, let's talk about long-term care costs. Statistically, 7 out of 10 of us are going to need it. Big surprise, right? We get old, we break down, and we're going to need some help. So here's some more sobering statistics. 2 out of 3 bankruptcies are caused by medical problems in the United States. 2 out of 3. That's the #1 cause of bankruptcy in the United States. The average retired couple will need $280,000 for medical expenses in retirement, which does not include the cost of long-term care. So those are big numbers. And how much does it cost in real terms? Well, the national average is $97,000 a year. That's actually an old number. If the cost rises, to put things in perspective, if it rises at a rate of 3%, in 20 years, it's going to cost $176,000. Now, is 3% a reasonable expectation? No, it's an unreasonable expectation because the cost rose 6% per year between 2008 and 2018. So it's unsustainable in my opinion, but that's the world we live in. So how do you pay for long-term care? 1, 5 ways. 1, you pay yourself. 2, someone else pays. What does that mean? The kids chip in, or maybe you find some long-term care insurance, which is something you should look at. Aid and attendance benefit. If you're a veteran, you're entitled to this, but it's need-based, and so you need to think 3 years ahead for this. Medicare pays nothing after 100 days, and Medicaid is the payment source of last resort. So what is Medicaid? It's a joint federal-state program that pays for all long-term care costs. And not all, it covers 49% of all long-term care costs. 49% of all long-term care costs. Now think about that. If 7 out of 10 of us are going to need it, and Medicaid covers 49% of all the costs, that's a pretty big number. So it's a tremendous benefit. And so, there's a lot of misinformation about this, this little niche, that they can take your home. That's not true. They may slap a lien order on the back end, but nobody takes your home. You have to give it away in a way that you can't access funds in order to protect them. That's not true. You have to wait 60 months to qualify, and that is not necessarily true either. It's a really complex area of law, surprisingly complex. There are exceptions. There are exceptions to exceptions, and we don't have the time to cover those. We would normally cover some case studies, but we have to do that at a different time. But we'll cover some options, in a cursory way in the next section when we talk about our options, which is the brass tack stuff. How do we do this stuff? So the third threat is failing to plan when you can. So, this is just another word for procrastination. Think before you speak, plan before you act, accomplish your goals before it's too late. So if you reach this state, it's too late. And if you reach this state, it's certainly too late. So You must act. Now, third section, know your options. How do we do this stuff? What are our options? Well, you have two at the end of the day. Do nothing, or in which case, you find yourself under the government's estate plan for interdiction, probate, estate administration. The government decides who's in control, who gets to benefit, and when. Or you do something, which is estate planning. And there are three core elements or questions. You get to decide who's in control, who gets to benefit, and when. While you're alive and well, ask those three questions. Who's in control, who gets to benefit, and when? You decide. If you become incapacitated, that's your power of attorney, or deceased, or your spouse becomes incapacitated, or remarries, or your spouse passes away, your kids will be subject to certain life events, future failed marriages, disabilities, bankruptcy, all kinds of things can happen. So you just shine your flashlight down the road as far as you can and envision all these scenarios, and you just ask those three questions and you decide what you want to happen. That's estate planning. You just have to walk the walk. Now, Medicaid planning, what is that? Really, it's about just getting your balance sheet to look right so that you can avail yourself of the benefit. And in the Medicaid world, there are two kinds of assets. One, countable assets. Two, non-countable assets. Countable assets are things that count against you, like money in the bank. Non-countable assets are things that don't prevent you, you can own, but don't prevent you from qualifying for Medicaid, like a principal residence. And that's about it, really. So strategies that are used are, transferring assets to, usually to a trust, or giving them away some other way, or spending down assets. But you have to tread very carefully in this area of law because, one misstep can be catastrophic. So you're dancing around really what is referred to commonly as the look-back period. And the look-back period in Louisiana is 60 months, which means that Medicaid, from the date of your application, will look back at all financial records of the applicant to determine whether there have been any transfers for less than fair market value. And if there have been, then there is a consequence. And in real terms, there are two kinds of plans in the Medicaid world. There's a crisis plan where you've done nothing and you have to check in tomorrow and, what do you do? Because you have too much. There's still things that you can do, absolutely, to save substantial, assets. But it's never as pretty as a pre-plan where, you can save protect every penny that you worked for. So should you give your assets away to the kids? Absolutely not. Why? Well, because you never know how they're going to turn out. So, one could die, one could go bankrupt, another one could get divorced. And then what happens to your safety net? It's gone with a wind. You're also leaving money on the table when you give assets directly to the kids. Why? Because they take a transferred basis in whatever you get them, transferred tax basis, right? So what does that mean? If you've got a stock portfolio of $100,000 and let's say you bought Amazon when it was $100, now it's worth $100,000, and you make a gift of that Amazon stock to one of the kids. They take a $100 basis. So if they go to sell that, they're going to pay tax on the difference between $100 and $100,000. Conversely, if you'd used a trust, it would get a step up in tax basis at death. So they can sell that Amazon stock tax-free. And the trust also protects the assets from risks such as death, divorce, or bankruptcy. The kids that would, put your assets, your safety net at risk. So it's a good tool and, useful when it's necessary. Now, it's all about, if you think about this stuff, you need to think ahead. You need to have some forethought, some foresight, and to see where you want to be, and then act to make sure that you can get there. And so we see a lot of people, and the math in this area of law is pretty complicated. So we use software to compute, break-even points, and it looks something like this. In a live presentation, we'd do a few case studies, and I can't do that in this presentation. But let's say, for example, you've got a couple who has about $750,000 worth of assets, home, stocks, car, cash, and they want to make a transfer now to start the clock. And so how does that work out? If you pre-plan, if you think ahead, and you're planning around the 5-year period instead of waiting to the last minute where you're in a crisis situation, how much can you protect, and how long will it take? Well, it may look something like this. So assuming those numbers, and you haven't seen the back end of income and the healthcare costs, all that factors in, we could immediately protect $624,000, but the balance of 145 is at risk to long-term care costs, but it's only at risk for 18 months. So if they stay healthy for 18 months, then we can protect an additional $3,400 a month until month 60, when it's all safe. So you think about it like a glide path. The longer you stay healthy, the more you protect until it's all safe. So everybody's got their own number. Everybody's assets, everybody's income, everybody's healthcare costs are different. And so we use an asset protection analysis worksheet to compute these things. It's just a one-page form that we can gather this information, plug it in, and what spits out is a MedQual analysis that will kind of give you a glide path to safety. So we offer this free of charge to anyone who's interested. So this is something, if you want to find your Medicaid number, then just feel free to reach out to us. We'll give you this analysis, this worksheet. You send it back to us, and we'll turn it around and let you know where you stand. So feel free to take us up on that. So how do we do this stuff? Usually we use some form of a trust. And what is a trust is a common question. A trust is a legal document or an agreement, and after it's signed and implemented, assets are simply placed into the trust. A trust can own anything that you can own, whether it's real estate, money in the bank, investments. The assets are held for your benefit during your life. And after you're gone, the trust assets are distributed by a trustee to whoever you name as beneficiaries pursuant to your instructions. So it's your master plan. There are two types of trusts, really, in the biggest sense. There's a testamentary trust, which is just a trust that gets formed inside your will. Or there's a living trust, which is a trust that you set up while you're alive and well. If it's a living trust, there are two kinds. It's either revocable or it's irrevocable. If it's irrevocable, you're going to do that for one of two reasons. For tax purposes, which means you've got too much money, you've got more than the federal estate tax exemption equivalent of $11.5 million per person, or $23 million for a married couple, and you need to get money over the fence to protect it from federal estate taxes. Or short of that, you're going to do it for some desire to achieve some asset protection, some level of asset protection for yourself or your spouse or your children. So that's usually the driver for an irrevocable trust. To get asset protection, an irrevocable trust needs to be in the equation somewhere. But let's talk about a revocable trust first. Think about this like an open box. A revocable trust, is you get all the control because you're the trustee, all the income, all the principal. You can amend it, you can modify it, you can change it, you can revoke it anytime you want. And so it serves as your master plan. And it works something like this. Now let's pretend that purple box is your revocable trust. And you set it up, right? And then you're the settlor, which means you're the one who created it. You're the trustee, which means you're in charge of it. You have the checkbook. You transfer your assets, change title of the assets to the name of the trust. Could be your house, could be money, could be anything. You name yourself as a beneficiary. So, it's for your benefit. So you're wearing all the hats, settlor, trustee, and beneficiary. You name somebody else as a principal beneficiary, or remainder beneficiary, maybe spouse or kids, somebody else. And then you simply, subsist in this state. If you want something, you need to go to the grocery store, go to the grocery store. You want to go on a vacation, go on a vacation. No problem, no questions asked. Now, if something happens to you, here's the shortcut. The trustee has instructions simply to give the assets to whoever's supposed to get them, pursuant to, your instructions in the trust agreement. So remember when, the judge signs a judgment of possession, which is a piece of paper that he signs with an ink pen that has the force and effect of law that puts people in possession of what they're supposed to get at the end of the probate process. Well, here you skip all of that, and the trustee signs, a similar piece of paper that says, you get this, you get that, you get the other thing. And so you're there without any delay. And so it's super convenient. The benefits are, often driven by the desire to avoid the cost, administrative burden of a probate, times 2 if you're married. Privacy, because, none of this is laid out in the public. And so, nothing's published in the legal recorder or anywhere else. So it's all, off the radar. It avoids problems with the power of attorney. So nobody questions the powers of a trustee. It's quick. There are no delays. Assets are immediately available. Integrates well with an asset protection structure. But one thing to keep in mind is that a revocable trust doesn't provide any asset protection. Why is that? Well, you can revoke it, you can amend it, you can modify it. So somebody standing in your shoes, which is what a creditor does, a creditor, whether it's a judgment creditor or Medicaid, Medicaid is just another creditor. They stand in your shoes. So if you can access it, so can they. And so it doesn't provide any asset protection. That's a myth. So be careful of that. I review trust for people that other people did. Not uncommon to, for someone to come to, after 5 years have passed, to say, will you please review this trust and make sure we're all set, because we set it up 5 years ago and now we need to go in the nursing home. And the answer, often is, well, no, you're not set, because this is a revocable trust. You haven't even started the clock, so you're not all set. And that's a bitter pill to swallow. So just be mindful. Now let's talk about irrevocable trusts for asset protection purposes, which asset protection may be driven by, fear of lawsuits or long-term care costs. So if you remember, a revocable trust is like an open box. An irrevocable trust is like a closed box. So think about this. I mean, this is a very rudimentary example, but it's the best I can do in this format and this limited time period. You live on the left of the screen, where you've got a house, you've got stocks, a vehicle, savings, maybe a little real estate. So that real estate is a hot asset. Maybe it's rental property. A hot asset is something that has innate liabilities attached to it. If anything goes wrong on that property, then the owner is liable. So most people who own real estate should wrap it in a bubble, put it in a limited liability company. Why? Because that compartmentalizes the liability. So whether it's, whether it's a piece of real estate or whether it's a business, you want to contain the liability so that things outside the bubble are protected, like your house, your investment portfolio, your savings. So then after you kind of compartmentalize hot assets, you start transferring things to the irrevocable asset protection trust. And remember, trusts are like ice cream. There's a million different flavors. And so it's not just as simple as saying, oh, this is an irrevocable trust, it's going to provide asset protection. No, it's got to be styled a certain way. And there are a lot of very subtle nuances that you have to be careful and mindful of when you do this. But assuming this trust is, properly drafted and confected and structured, then you simply close the lid. Remember, open box, close box. You close the box and you subsist, just like you did with a revocable trust. Now, you're safe. You sleep better at night. And so if something happens unforeseeable, like a car accident or, an animal wanders out in the road and causes an accident, everything inside the box, if the trust is properly confected, is safe. And it also doesn't count against you for Medicaid purposes. So that's the idea. So do I need a trust? There are different considerations that go into this. Everybody's different. These are some of the factors that may play into it. Probate costs, delays or estate litigation, if you see that coming, or even the potential for it. Protecting, your family, your legacy, running out of money, family discord, loss of control, nursing home poverty, or lawsuits. These are all factors that may push you towards maybe a trust-centered plan versus a will-centered plan. Whether it's revocable or irrevocable just depends on, what dragon you're trying to slay. So, that's, everybody's different. But where do you start? So, first, you got to do something, right? You can't not do something. You have to act. And what does that mean? Create your own rule book, whether that's a will or it's a trust. Just do something that works and reflects your voice, because you can't get these things off the shelf. They need to be personalized to, there has to be a close examination of your, immediate circumstances and those in your periphery, looking down the road to properly build out the structure. So it's built to suit. Then you integrate it, right, with your life and your stuff, which means you account for non-probate assets. And then you maintain it. So you can't just put it on the shelf and forget about it. You need to dust it off every so often to account for changes in law, changes in health, changes in other circumstances that may affect your plan. But once you get it set up, maintenance is just good discipline. And we help you with that. So without all three, it usually becomes ineffective after some period of time. So remember the goals of this workshop were to understand what it takes to properly protect you and your stuff, to protect your estate, and to identify whether your current plan meets your goals, whether you're all set. So are you prepared? Think about this on a scale of 1 to 10. How prepared are you to withstand an event that suddenly renders you incapacitated or worse? 10 being totally prepared, 1 being totally unprepared, or somewhere in the middle. Think about that, especially in light of what's going on today. How prepared are you to withstand a sudden catastrophic business or personal loss? 10 being totally prepared, 1 being totally unprepared, or somewhere in the middle. So if you're not a 10, you need to look at it. And that's the easy part. How do you get what's missing if you're not all set, or you think you might not be all set? Here it is. All you have to do is go and complete our webinar evaluation form. It's on our website at theaslawoffices.com/workshops. Just go. It's very short. You don't need to download anything. We're just looking for a little feedback on how we're doing, because we can always do a better job, and rate this presentation. 1 being not so good, 5 being pretty good, or somewhere in the middle. So give us a little feedback. And then at the end of that very short webinar evaluation form, there's a box you can check for a free personal assessment. We will give that to you, no charge. It's a tremendous value. At this personal assessment, what we do is we give you a checkup, an audit. You bring us all your estate planning documents, whatever you have, whoever did it, doesn't matter. We will take a look at it and check it and make sure that the documents aren't defective. And if they are, we'll let you know. We will also provide you with your Medicaid number if you want that. And 3, after touching on a number of topics of concern and kind of clustering your concerns, whatever they happen to be, we will provide at least 3 options to create what's missing, so you can tie it in with your plan and your life. But you have to act, remember that. So that's the takeaway. Assess your needs, create what's missing, tie it in with your life. If you feel like you have a problem, or you might have a problem, or you're not all set, it's not going to go away. So just muster up whatever it takes to look at it. And that's our job, is to get you to do something, no matter what it is, and not nothing, because that's what gets you in trouble. So that said, thank you very much. I hope you found this informative and helpful, and we look forward to working with you at some point in the future. So hopefully this has raised questions. It may have raised more questions than answers for you, which is a good thing, because that's my job, to get you to think about your assets, your estate plan, and your decisions. So if you have any questions, feel free to reach out to us. For anyone with mobility issues or travel concerns, we work with clients all over the world through technology, and we can work with you in the comfort of your own home. So in the meantime, take care, stay safe. We look forward to the opportunity to help you and your loved ones for many years to come.